and by how they have make a more faster trials, more efficient trials. All those things can be addressed only by addressing the technologies that we have now so far. And let me point out the first question. The first one which I am going to ask is, which is a cliche question, whether there is a new law is required or the old law is sufficient. Because you know that there are so many changes, amendments are there before the BSA itself. And then because of the new technology only, they have made a change in the BSA. That itself is a technological change alone. Actually, my senior professor has already said that there is no much change in the Indian Evidence Act. When we compare with the other two laws, you can see that only a technological implementation is only there in the new law. And so my first question is whether the old law is adequate or whether there is a change. I mean, a new law is required. If a new law is required, I'm trying to club the two questions together because of the time constraints. So the next point is that if the new law is required, then can you tell me what are all the most significant changes that is there in the BSc? First, Chetan.
Good afternoon, ma'am. So, firstly, I would like to answer the question from in a chronological order, whether it is actually needed or not. So, as you've already summed up that there is no significant changes that has been found in this compared to the other two laws that has been brought in now, ma'am. We could say that there could have been an amendment instead of such such provisions that has been inserted in the new Evidence Act that has been came up now, that is BSA. So I think they have just tried to run the IT Act and the Indian Evidence Act parallelly, which was a measure that has already been culminated in the year of 2000 itself. And after that, even in the 2013 amendment, in all these amendments, they have tried the legislation have more strongly tried to profound this law to the digitalized era of this country. So I think only the amendments would have sufficed, and there is no need of particular new law itself per se for the governing the Indian evidence. I think Indian Evidence Act earlier was actually good, and only amendments would have been sufficient because it was governing all the provisions. I think even the significant changes, if we would have point out here, I think only the digitalization of evidences and digitalization of records, all these things will be summed up. So I think this digitalization point would have come through amendments itself, which was already coming on the way, right? Like we have already witnessed those amendments in 2000 itself, and I seriously didn't figure out any significant changes as such in the new law. And apart from that, I think this is a complementary measure from the BNSS to BSA. That is the provision where in BNSS it has been stated that there must be an obligatory presence of the forensic team while investigation is involved. I think that may be a provision that is being complementary to BSA. So I think there are the other two new laws were really good, and the provisions included in that was really commendable, and it was actually complementing it to BSA. But BSA as such, when we talk about, is actually not needed because the already existing IEA was really good. Amendments would have sufficed. This is my point of view. Thank you.
So she is of the view that amendment is not required because James Stephen is good. He is the best. Okay. Yes. My professor used to taught me like it is like a poem. Once you study Indian Evidence Act, if you have study like a poem, like you will never forget Twinkle Twinkle Little Star. Same way, you will never forget Indian Evidence Act. Like that only he has drafted that. So now she is also of the same view that there is no need of an amendment. Indian evidence is sufficient for future as well. Amendment is needed, but as such there is no need of any change. Okay. Then anybody from Chetanad want to add some more point? Okay, then AGLC.
Yes, actually, I do support with that because uh, there is no change in drafting. The sections also read as censor for Indian development. So there is no need of the new BSA as well. But I believe that the drafting committee would have think that. So we have we are redrafting the other two laws. So we need also redraft the Bharatiya Sakshi Adhyay. So I don't think so. There is no much necessity of this Bharatiya Sakshi Adhyay. So they might think that because we are redrafting or reenacting Bharatiya Nyaya Sanhita and Bharatiya Nagaric Sanhita, so we need also to draft Bharatiya Sakshi Adhyay. So there is no need or necessity to draft Bharatiya Sakshi Adhyay.
Anyone else?
What I could feel is when both laws which use this again have been changed. The subsequent changes that is required in these two laws has to also reflect into BSc. So if left now, I don't think it will be possible for it to change. That will be the main reason for it to go.
Okay. So regarding the primary evidence, when you see the primary evidence, you can note down that all the, I mean, whatever you have said is there is, I mean, no need of a much change. It is already there. Amendment is sufficient. But when you see the primary evidence, you can see that all the electronic evidences has been added as a new change in the BSc. Electronic evidence, how we will submit the electronic evidence? That is a question. Generally, for how we have to prove the fact, that is a question, because it is a lex forum, the law of the forum. So here you see how you will submit the electronic records or how you will submit the digital evidence that is provided under the primary evidence. And even the temporary files can also be included as a primary evidence, which is also provided in the primary evidence section. Okay, so that is when it try to implement such things, it will be very difficult because temporary files is also as a primary evidence. Earlier we have studied that primary evidence, secondary evidence, there is a differentiation. Primary evidence as such we will submit. Secondary evidence, if you are submitting a Xerox copy or I mean, they have given a certain enlisted certain things. Like if you are submitting this as a copy and a certified thing, that is considered as only as a secondary evidence, and also we have studied. But here, even the temporary files of electronic evidence is also submitted as a primary evidence. Understood? So the changes are there. Okay, but how far we will implement those changes is important. Understood? So with that, shall we move on to the next one? So we are into the world of communication. All whatever we are communicating, even during the class also, we are communicating using our phones. So my question is, the mails and messages, all these things can be incorporated as one of the evidence. Understood? As per the new law, mails, all kinds of digital platform, whatever we are using, and in PNSS also, you might have noted down that even if you are sending the summons through the WhatsApp, that is required. That is enough. That is what it is given. So, I mean, though it was there during the COVID period, and she has stated at that time that it is there during the COVID period also, we tried to send such things, but now it has already been incorporated in the DNS. So, my question is that whether these messages and these digital platforms, all kinds of emails, how this will affect or impact or give a good trial in our criminal proceedings.
Yeah, considering the primary evidence, also people want to take the primary. According to the judgment, the, of the judgment, but it clearly says that the statement of the evidence should be on the not on the name. It should be on the number. and the new TNS has failed to mention the expert. It's considering the IT Act 2000, taking the expert meaning from the IT Act. It failed to mention the expert in the TNS. Basic.
Actually, there is a provision which says that, expert examining of expert, okay, where they have mentioned expert, who is called an expert, okay, it is already mentioned in PSC, okay, and they've added their other field also they have added, okay, it's already there in PSA. Any other point?
Ma'am, as far as the digital evidence is concerned, the only point that has to be kept in mind is that while examining it, they should ensure that there shouldn't be any manipulation of such evidences. Since you asked that even males have been included under this primary evidence now, like what, whether it will be factual in a positive or a negative way, like I would like to say that it is actually positive. Like they can be made accountable for each and every word they state in that. But also it has a negative view that it can be easily manipulated, like unlike other evidences. So that has to be taken care of. But also Indian Evidence Act on this BSA has the expert opinion that can be given by certified computer technology experts. So I think they should be effectually managing things, and they should come up with. And also, the common man should be given a clarity as to through which through which platform or through which design infrastructure such digital evidences admitted have been checked and have been passing through to taking into the admissibility point of view and all now. So I think the common man should be given a clarity through which test and all it actually appears, and it has to pass on to in order to reach out to the court as a credible evidence. So, what all the actual measures that are being taken in order to prevent the manipulation of such digital evidences? So, that is what is.
Anybody from this side? Yes, from Chettinad. Okay. So as she said, there should be, we are giving more importance to the digital era, the messages, emails, whatever maybe we are considering as a primary evidence. But whatever you are considering, it should be reliable and authentic. Okay, that is a point. That is important. Okay, how we will know that whether it is reliable or authentic? That is a second question. That should be addressed by the honorable court. Okay, now they've given the power to the court. They have given, he can accept primary evidence. So how far it is reliable? That is a question. That is a question of fact. Understood? And shall I move on to the next, or anybody wants to add any point to that? Yes, ma'am.
The Act itself, they have given section 63, admissibility of electronic records. In that, they have gone on to schedule, which says that it has to be certified. So there's a check. They've already given some start points for it. So an expert has to check the evidences that are being given and certified, which will be admissible for it.
Yes. Anybody wants to add?
So whatever proof we are trying to give, no, they will be taking the signature of it, like through sharp physics or MD5 or through some algorithms, whatever content is there, from that they try to generate the signature. And whenever we are trying it, when we are producing it before the court, again they will re-verify the same signature whether it is getting matched. If it is not matching, they will be able to identify that someone has tampered it. If not, we are sure it is untampered. This is only for evidence which I am trying to produce before the court is considered by the court. But
there are cases for that. So many cases are going on for that. You are manipulating, you are changing the hashtag, all those cases are going on. Okay. Now, whether all these are affecting the right of an individual, whether the new law will make any change in the right of an individual, as I said, the fair trial and speedy disposal of cases is also an important aspect. Okay, all these changes should be for the common man. Understood? So there should be a right which is vested with the individual, that there must be a speedy disposal of the cases, there must be a fair trial and faster trial and more efficient trial. So whether these are all addressed by the new change or by the BSA. Chetana.
Ma'am, the exact question is that you're asking about burden of pendency cases or
Individual right of an individual for speedy disposal of the case. Whether the trial, whether all these new changes, right? We are giving the digital evidence, that is a primary evidence, whether all this affect the right of an individual.
okay, ma'am. So,
Our college
as
channel,
far as
no?
the privacy of the individual
No,
is
no, how to
concerned with
drive.
recording such digital
Carry on.
evidences, it is actually infringing the privacy of the people. But then, on the other side, until and unless, as I already pointed out, the evidence is until and unless the evidence is being manipulated, everything when a person is being accountable for whatever he states, then it is actually commendable measure in terms of criminal justice system. It is because that even prior to this law, when no one was accountable for what he tells through the text or mails or something. When that was not given that significant admissibility value in courts, the people took it so easy, and there are a lot of cases even in colleges. Colleges are the problem is that though it does not happen in a physical environment, that is around the environment which I mentioned now, through such an online person to threaten another person prior to this law. But now I think since they will be held accountable, everyone will be cautious and careful while using it, and it is seems to be infringing the private right of a person. It is actually a commendable measure as such when considered at a whole, because it is crime when it is concerned. It is actually against society at large. It is not against an individual right now. So I think this is my point of view for this particular question. Right?
Yeah. Last time, my fellow friend Edumali has taken about the right to fact trial and the speedy justice. Yes, of course, if the evidence is speedy trial may not be achieved. In addition to that, ma'am has stated about the right to privacy. I think everyone might know about numerous cases as pending before the Honorable Supreme Court. The admissibility of WhatsApp chats in the as evidence. There are many problems regarding that. If there is a case between a husband and wife, whether the WhatsApp chat against a wife or a spouse is admissible or not. So the digital evidence as being considered as the private evidence are made as a primary evidence. There is a conflict that whether this can be admissible as a evidence or not. Another thing is that held accountable means the right to speech and freedom expression may be affected. Of course, we have reasonable restrictions as well. But this has also be a concern, several concerns by several jurists as well. So, from BSc, we have a right to fair and speed justice, yes, gets affected, and right to privacy is also gets affected. So, this raises a concern, and I hope the Supreme Court might look into that also.
There must be witnesses. Certain persons are restricted from compelling to be a witness. Like husband can't be compelled to give witnesses against evidence against a wife. Similarly, Similarly, the wife cannot be compelled to give witnesses against the husband, and the client advocate. Okay, and regarding the if it affects the integrity of India, security of India also, such evidences shall not be compelled to be given. So it is already there. So the privacy, how it is affecting I'm just focusing on the area that whether the electronic evidence will affect the right of an individual. When you are submitting the electronic evidence, whether that will affect the right of an individual.
No, actually, the lacune or the conflict arises is that the witness of husband against the wife cannot be cannot be used or cannot be compelled. But the witness of wife's WhatsApp chat against the husband is not clarified. It's not still pending before the Honorable Supreme Court. As far as the BSA is concerned, being the pendency in the court, so there arises a lacune, there arises a conflict. That's what my point is.
Regarding submission of client evidences to the court, even now it is only the advocate who is doing it. So it is not an individual or citizen who is led to do, except as to say giving a complaint. And that too is not a normal daily affair. It is normal that it is the professionals who are going to do it, it is the advocates. An advocate is competent enough to equip himself to upload and to have the evidences checked on his side and upload. So that way we are not going to infringe into us a citizen by doing by giving evidences to court to respond.
Anybody wants to add points?
That husband and wife chats are being concerned. I think generally it has already been covered under the privileged communications, like as you mentioned. So yeah, that's what the clients advocate and the wife, husband, everything. Specifically when privacy is concerned about digital evidences. So how it is concerned is that when the communication panel is just changing now. There's a simple thing to be defined here is that when it is in the digital platform, just the platform changes. That's it. When the very notion of this privileged communication have been saved for this purposes is that they have to preserve certain communications. They shouldn't. They shouldn't compel the persons to let out or put out the communications into the court for court as witnesses. So they cannot compel such witnesses to come up and say what are those privileged communications as such, according to the Indian Evidence Act. And when digital evidence is concerned, there is no special attention is being given to that. I think only the platform changes. Only through digital platform, but the communication panel changes, wherein all the purposes of preserving them or not compelling those witnesses to come up and say those privileged communications remains the same.
Communication and the ministers. I think a special section is there which says that it will be excluded and it is not permissible in any court of law as evidence. So that's a very important addition, which I think Stephen James put in Percy. So President and Ministers of India, communication again, published.
Can you tell me how far BSA will help to finish the trial very fast or to in a fair manner? Can you tell me? Or even if we have made so many changes like electronic evidences and all those things, there won't be a possibility of finishing the trial so fast.
Digital penetration. As per the statistics of 2023, 1.1 billion mobile and internet users in India out of a total population of 1.4. So the chances or a probability that majority of the crime scenes might have one or the other
recording it in a mobile phone, which that we are seeing in all the crime scenes recently. So the inclusion of pervasive the digital evidences for crime recordings is a very positive step which will ensure speedy trial, especially in the day before yesterday in the Ujjain rape case. A rag picker was raped broad daylight on the roadside, and nobody came forward to help her. Everybody was recording it on mobile, which became viral on social media. In Ujjain, it happened 2 days back. So most crime scenes, we have people recording it, so there will be no scarcity of evidences. If people are willing to come forward, it's coming already in the social media and other platforms. So this digital empowerment can be a positive side in case of speedy trials and ensuring justice for the victims.
Chechana.
Yeah, well, like I would actually go with Brown's point that digitalization was actually the main purview and main, I would say, the main part and parcel of the process of the entire regionalization process of the criminal justice system that the legislation intended to bring up. So I think the digitalization, digital record keeping, digitalization of evidence and admissibility of digital evidences and certifying it through the experts, everything will actually ensure the time period that is invested in bringing up the evidence. Initially, in sense before the amendment that came with respect to the IT Act and IEA, before that, the cases when we actually see the data, the cases where actually the trial proceedings took a lot of time to come up with credible evidences. I think after digitalization process and making it admissible through this BSA, as ma'am pointed out rightly, the time period for in the time period invested for bringing up such evidences will actually come down, and thereby it ensures fair and a very speedy trial, I guess. Thank you.
Again, trial, delay in trial. Okay, so delay in the process doesn't mean that, if we are adding digital evidences, we can finish the trial very fast. Okay, we are not, we will see, we'll check to all those points, after 5 years or 10 years, we'll check all those points after 10 years only. We'll be able to say that because of the addition of the digital evidence, we can finish the trial very fastly, and our trial system and our process judicial system is going very smoothly, more efficiently it is going on. Okay. Now, we have just now we have told about the expert evidences and all. Now, tell me whether the expert opinion will make any change in the new bill, BSA, or expert opinion will affect the trial of BSA. It has been already. Any new change I am asking?
The word other has been added to include any other experts coming to the picture.
Earlier it was fingerprint, science, foreign law, and now all areas, experts from all areas. It's not a conclusive proof on anything, but it helps the judges to arrive at a conclusion or a judgment based on the expert opinion from various fields. There are various new fields that has emerged over the years. So experts from those fields, their advice is also. An expert is one who has specialized knowledge on a topic, on a subject, and experience. So their inputs will add more credibility and more clarity in the judgment process.
Anybody wants to add from Chetan? So I'm going to conclude. Uh, see, as we have seen today that there is a evidence is not like a static. Okay, it keep on changing. Okay, when the society changes, the law should also be changed. Okay, that is what the law we have studied, and it is now the role is for yours. I mean, up to you. It is the future lawyers. As a future lawyer, how you implement these rules, because in our I mean objective of a BSA itself states that it is a consulted and general rules, okay, and the principles which is provided under the new I mean BSA objective. Now the rules are framed, everything is set. Now how you will implement? After all, whatever it is written, the ultimate object of all the law is to drive the justice for all. Now, as a future lawyer, how you will implement and how you will make it as a in a fruitful sense. That is a question. Okay. Now, all the best. Thank you for a wonderful session. Thank you. Thanks so much.
All right, student, you can proceed for your lunch. Okay, our students will guide you to the examination or the backside, so you can go for the lunch. And after that, there is certificate distribution. So after that, after lunch, together there only there is a certificate distribution for you. Okay, thank you.